Okay, let's get started. So thank you guys for joining us on this webinar on navigating estate administration from the diaspora. I'm Rudom Gwagwa. I'm one of the principals on the corporate side of the team. Before I hand over to my colleagues, some of whom are on the ground, I thought, I'd give a bit of context as to why we're having this presentation. Over the past, I'd say, year, we've had a lot of people inquiring about the estate administration process, particularly from the diaspora. I think obviously it's a taboo subject area culturally, but I think what's important is for people to have information on how the process works. And I think it's also important to remember that, this process is about honoring someone's life's work, their possessions, should be respected. And we must respect the wishes of those who pass. Understanding this process allows people to navigate this with more ease and to plan, to help their families plan for when that moment comes. And that tends to ease, that mourning period if people aren't, stuck going through the process, a very arduous process that the system has. We're hoping this presentation will give you guys some insight and help you feel a bit more empowered if you're faced with this process, but also so that you can turn to your estate planning for yourselves, which really, would help you get through this process down the line. There's a Q&A box there. You'll have that option. Feel free to drop in questions in there. Any upvotes, we'll try and address the questions that have more upvotes first. But yeah, we'll try to address questions at the end. Feel free to, pick any questions you see fit based on the subject area. So with that, I'll hand over to my colleagues to start the presentation.
Thank you, Rudo. Let's see. And good afternoon, everyone. We are Fresh Legal Perspectives, or FLP, and we are a client-focused legal services provider, really focused on delivering clients' needs at the highest quality and sharing the risk where appropriate with them. Our key values are collaboration, quality, and integrity. And we focus in primarily several areas of corporate finance, project financing, corporate management, and estate administration. Your presenters today include my colleagues Joshua Takawira and Irvin Chuara. Joshua is our principal who is leading our corporate matters around governance, company secretarial risk management, regulatory compliance, and of course, estates. Irvin is our principal around project finance and has broad experience in project development, financing, and general corporate transactions. Myself, Ajne Mugwagwa, I'm a principal as well, primarily focused on corporate finance and have over 15 years of experience advising companies and business leaders in transactions and in financing. And as Rudo mentioned that the Q&A chat box is there for your questions. Please do collect them as we go along so that we can really be more responsive to your needs as we provide these materials here. And for those who have specific inquiries or needs following this call, we are offering a free 15-minute consultations for those who have attended, and also a discount on a paid consultation for having attended the webinar. So please do look out for that follow-up for those links so that you may be able to utilize that and get a benefit having attended the presentation. And with that, I will set forth now the agenda here, what we will be covering today. We will be going through the Administration of Estates Act, which is the framework around which we will be our topics around. And then we'll follow that, we'll do a current view of the estate administration in Zimbabwe as it is today. And then follow and finish that with how we can actually help you and really additional insights we can provide. And with that, I'll pass over to my colleague, Joshua, who will take us on through the Administration of Estates Act.
Thank you very much, Hazi, and Rudo for that beautiful introduction. My task today is quite a straightforward one, and it's to talk about the Administration of Estates Act. The Administration of Estates Act is an act that regulates the administration of estates, right from reporting the death through to the distribution of an estate. Now, when a death occurs, the law requires that that estate be registered within 14 days of the death. Now, there are certain places where this registration can be done, and it's usually the High Court of Zimbabwe. And the High Court has 4 offices in Zimbabwe at the moment: one here in Harare, the other one in Bulawayo, one in Mutare, and another one in Masvingo. So if a death happens in one of those areas, it's easier for you to just walk into any one of those offices and register the death. But there are instances where death happens somewhere in Jocholo or in Lotito, in Cholocho somewhere. The law states that you can register at any of the magistrates' courts there. The reason why they do that is because the failure to register a death within that particular time can result in you having to pay a fine, or let me say criminal consequences that are there. Either you have to pay a fine or 1 month imprisonment. Now, the law says there's what they call a level 1 fine. A level 1 fine is not much. It could be between $5 and $10. However, the possibility or the risk of getting into prison because one failed to register a death is quite high. We know for now that the Master of the High Court hasn't really been enforcing these things, but at the beginning of last year, there were talks of him starting to enforce those things. And sometimes you when you think about it, you don't want to be the first person to be attacked by that. Now, when that death has occurred, the master is going to require the person who's reported the death, who is usually the next of kin, a spouse, or the person who's living with the deceased at the time of the death, to register that death within that time frame. But when that death occurs, the deceased leaves behind assets, and he doesn't die with the assets. So those assets must be held by someone at that stage. Usually, if the deceased was married in community of property, the surviving spouse retains the custody of the joint estate or the estate of the deceased person. But if the deceased was married out of community of property, which is the majority of the times here in Zimbabwe, because most of our marriages are automatic out of community of property, the responsibility lies with the person who was living with the deceased at the time of the death, or the partner, or the next of kin, or the children. In some instances where the marriage is a polygamous marriage, for example, the person who has to hold the assets is that particular spouse who would have lived with the person as husband and wife at the time of the deceased's death. Next slide, please. Now, this slide talks about the grant of letters of administration. So the master plays a very important role in administering estates, and one of them is granting what they call letters of administration, which is essentially letters of authority to administer that estate and to distribute that estate. That process is done in 2 ways. Number one, it's either the executor that's being appointed at the time, the person who's being granted the authority, has been nominated in a will, or in instances where there's no will, there's a separate process for that. Can you please move? May we please move to the next slide, Rudo? Now, this is where there's a will. The master is going to administer the estate in terms of that particular will, provided that the will is a valid will, number one, and that number two, that will is appoints or properly appoints an executor. So where there's no dispute with regards to the executor that's been appointed in terms of the will, the master is going to nominate that person that's been appointed at that stage. But where there's no will, the process is slightly different there, because the master is going to require that a meeting be held at his office, which is called an edict meeting. Usually, that meeting is a physical meeting. They haven't started doing virtual meetings for those particular meetings. So when that meeting is called, all the interested parties, particularly the people, the heirs to the estate, maybe the children, the spouses, if there's one spouse, two spouses, if there are two spouses, have to go and meet at the master's office and nominate an executor. Sometimes creditors and next of kins are sort of invited to those meetings to sort of pick the executor at that stage. Now, where there's a dispute regarding the picking of that particular executor, the master generally prefers the spouse or a spouse to be an executor. And sometimes what generally happens is that the master will pick a third party, an independent party, to be an executor. Where that third party has been picked to be an executor, the estate will have to pay for those particular services. So which really diminishes the value of the estate when it gets to that. But there's something very important that it could be of interest, particularly to those in the diaspora that have been nominated as executors. As a general rule, an executor must be ordinarily resident in Zimbabwe. But there are exceptions to that rule sometimes, and the exception is this, that number one, the person who's been nominated as an executor has an address, a legal address here in Zimbabwe, where documents may be left and served. But number two, where the person who's been nominated as an executor appoints a power of attorney to act on their behalf while they're here in Zimbabwe. But sometimes the master will require that that particular executor provides what they call a guarantee or a bond. This is meant really to make sure that the person who's going to be acting on behalf of the estate acts accordingly and according to the law, and fulfills the fiduciary duties that Evan is going to address later properly. Where, for example, the estate or the executor has failed in his duties to a point where some of the beneficiaries of that estate have lost part of that estate, the guarantees and the bond may be used to compensate those beneficiaries. So that's how, in a nutshell, the process happens. But there are certain steps that have to be followed in the entire process of administering the estate. The first stage we've talked about is the registration of the estate. And one thing that I may have missed about the registration of the estate is that the master may require you to provide certain information. And that information usually is you need to provide a death certificate and what they call an inventory of assets, as well as a list of liabilities that the deceased may have had at the time of his death or his or her death. Now, The second step would be the grant of letters of administration, where we've discussed that. But once the letters of administration have been granted, the executor has to do certain things, and that's in that slide, step 2 and step 3, which is to advertise for debtors and creditors. Just letting the debtors and creditors know that there's been the deceased is normal, and that those that have a claim or those that owe the deceased must then submit their papers. Usually what happens in those circumstances is Parenyatwa, I know they are very big in following up on their debts, and some other hospitals. But secondly, I know Tel One also generally makes sure they have someone who reads those things to follow up on certain debts that the deceased may have had. So it's an opportunity for people to then lay their claim. And that process, really, that advert has to run for 21 days. It is done at 2 places, either at a local newspaper. Generally, it's been accepted by the master that if the deceased passed away in the bottom half of Zimbabwe, the Chronicle would be the right newspaper to advertise in. And if it's the top half, the Herald would be the newspaper to advertise it. But the government gazette is standard. You just advertise it with the government gazette, and that takes a period of that advert has to run for a period of about 21 days. Now, the next step is the preparation of the liquidation and distribution account. Now, the executor is going to be required to advertise and prepare liquidation and distribution account, which is essentially what the assets of the deceased were and what the liabilities of the deceased are. Now, after that, the executor will have to advertise again that liquidation and distribution account for another 21 days. After those 21 days, the master is going to make sure that is going to approve of that distribution account, and then gives you permission to dispose of the assets that are there. It's important also to note that the executor at no stage, at either one of these 3 stages, is the executor allowed to sell any of the assets that are there without the consent of the master. The master would have to give consent to sell, and once the master has given consent, you can sell and then distribute. And then there's an entire process of distribution. Once distribution has been done and all the heirs get their fair share of the estate, then starting from there, the estate is going to be closed. But there are certain duties that the executor has, which is where Evan is going to take on from to explain what the duties of the executor are, and then we take it from there. Thank you. Over to you, Evan.
All right, thank you very much indeed, Josh, for that. And welcome everyone who's here. What Josh was effectively just explaining there, which is very useful, is the process involving the appointment of an executor. What I'm going to delve into is a little bit more into what exactly does that mean when someone is being appointed as an executor. What are they required to do, and to what standard are they required to do those things? Now, thinking about it, if one were to take a step back, essentially what we're saying here is when someone passes on, they would have died physically, but at law, that person continues to exist until that process has been finalized by the master. And this is the process that we're dealing with. So someone has died physically, and now it's their legal person, really their name, any contracts that they have, or any legal title to any properties that they hold, that will be seeking to handle. But here's the point. Because someone has died physically, it therefore means they can't do that themselves. And hence the process of appointing an executor who is supposed to act on behalf of the dead person. Now, that becomes a very important thing to note and is a very good point of departure, because being appointed as an executor does not at all mean that you know, if it's in relation to property, for example, it doesn't mean that the property becomes yours. It pretty much and only means that you are acting on behalf of the deceased person. And so when you've been appointed an executor, you have certain duties that you're supposed to do. And those duties are really formulated around the fact that it's not your property that you'll be dealing with. Now, as you see on that slide, I won't be going through it verbatim, but as you see on that slide, you can imagine and you start to see that when you've been appointed to represent someone else, it's quite common knowledge that, you know, people keep certain things that they own that not everyone else will know about. So if you've been appointed as an executor, the first thing you would want to do, having gone through the process, is to identify what it is that the person owned. And that's what you see on that slide when we talk about creating an inventory of all the property. It might be houses, it might be commercial buildings or anything like that that's immovable, or indeed it could be movable items like cars, watches, or even art, anything of value that the person owns. The executor would have to collect and sort of collate all of that into a list and say, well, this is what the person owned. Now, after knowing what the person owned, you then have to assign a value of those things. And that process involves engaging other experts to do valuations, etc. So if it's property, might be going to estate agents, and they go through their processes to value the houses or any commercial buildings, etc. Now that you've identified the assets, the natural next step is to find out if this person, the deceased person, owed money to other people, any liabilities that they may have. Now, of course, this might prove a little bit difficult if you have no personal knowledge, and therefore the process involves having to advertise it in the government gazette, as Josh was saying, or in the newspaper. The whole idea there is essentially to make as much effort as one can to try and identify all of those creditors. Now, this process is managed by the master, and you know, with everything to do with court, they tend to have certain rules around timelines and dates and stuff like that. And so, just as Josh was saying earlier, when you advertise inviting for creditors, they too have a time limit to lay claims. So it's not a matter of someone reading an article and finding out that X has passed on and they're not doing anything until until after about 3 years. By that time, the estate may well have been closed. So to make sure that there is proper administration, everything is being done on time, the master tends to set out certain times when people can lay these claims. Now that the executor has identified the assets, they've identified all the creditors, and therefore the liabilities that the deceased person had, the next stage would be to identify his beneficiaries, his heirs, the people that would inherit this property. So children, if there are no children, siblings, parents, etc. Now, we may take it for granted, especially when you say children, especially given that often executors are people that are appointed, in the family, and from time to time, or generally, they would know, who the children were and whatnot. But it's not unheard of, and I'm sure many of us here would have had experience where children turned up on the day, on the day of the funeral, with the mother claiming that, well, look, this man sired this child, and this child is not known. And, that person remains a child. And so an assessment would have to be done. And that is a job for the executor to identify all of those people that could be beneficiaries, that could be heirs, so that when all the processes are done and that process is now, or that property is now being distributed to the beneficiaries, there are no beneficiaries that are going to be missed out or anything like that. Now, before we get into the distribution aspect of it, just after setting out these duties, I want to turn to the standards of which the executor is held when conducting this. And this is found on the next slide, please. So now, like we were saying, that when you've been appointed as an executor, you are acting on behalf of someone else. This property is never at any time yours. It remains the property of the deceased person, and therefore you're acting on their behalf. And so taking that responsibility is not something to be taken for granted, because there are personal liabilities that will attach to the person who's chosen to become an executor, because if you do not act diligently or with honesty, and so you sort of perhaps attribute the wrong values to properties, or you miss out certain properties, doing that effectively means you put the deceased estate at a disadvantage, and therefore the property that's to be passed on to the heirs would have been reduced because you didn't do your job properly. So being an executor is something that's very, very important. There are personal liabilities for those debts, and to an extent even criminal sanctions if you haven't done that job properly. But in essence, a person must act with honesty, with diligence, and making sure that the assets are being valued properly, and all of them being identified. Now, there is an interesting point that arises when you're talking about these standards. If someone else has been appointed an executor in any state that you're interested in, these are important standards to know so you can hold them to it. At law, we tend to, there's this jargon, if you like, that they have fiduciary duties, right? Because they're holding that property on behalf of someone else. So one should never be afraid to confront an executor and find out where they are in the process, what steps have been taken to make sure that they're identifying the right things, because they must be held to account when carrying out these duties. So it's not just a matter of someone has been appointed an executor and what they say goes. That's not how it works. That responsibility remains with the master, and the executor is supposed to act as a professional in carrying out his duties or her duties, and then presenting all that information to the master. Now, on the next slide, I want to talk a little bit about about a case. And from that case, I'll then just give an example, delve a little deeper into what these duties are that we're talking about. So it's quite ironic if you think about it. And if many of you remember, back in the 90s, there was quite a popular drama in which Oliver Mtukudzi actually acted Neria. And funny enough, he even sang a song about it. If people remember that drama, it really was centered around this issue to do with someone who passes on, a father and husband had passed on, leaving children and wife. And father and husband's family didn't treat the wife and the children properly, even threw them out the house and stuff like that. And so you can see in that particular drama, they were demonstrating how not to be an executor, what not to do, because there are laws, there are processes that are to be followed. Now, where the irony comes is that in his own case, when Tuku passed on, there were issues with the will, but we'll put that to the side for now. But the executors that have been appointed, and many of you might well have seen this in the press in the last few months, especially towards the end of last year, where his children were, coming out to the newspapers, on radio, complaining about how their stepmother had handled this estate. Their stepmother was one of the people that had been appointed as an executor. And according to the children, there were many complaints of properties that were not accounted for, monies that were used, they're not even recorded, you know, all these sort of claims. So without really talking much about Tuku's case, some of the things to expect, now this is us diving deeper. If one is being appointed as an executor, they need to, it's not a matter of saying, well, do I know of any property? One, you may think, let me call the family, set up with the family, find out from the family if anyone knows of any property. And if you are told of any properties, you can then follow up on it, go into the deeds registry, find out if the deceased had any properties registered in his name, any companies at the company's house, etc. So all of that becomes part of a diligent search of what this person owned. Now, here's the reality about what happens in Zimbabwe, especially when you're talking about some people who are the elderly and much older than I am, because there is a time, I understand, in Zimbabwe when records management was pretty poor. So often some records have been lost. In some cases that we've dealt with, some people had different names and accessing certain registries was difficult and stuff like that. Here's the point. When one has been appointed as an executor, they're acting in a quasi-official role, because you would have received those letters of administration that Josh was referring to. So one can actually approach any deeds registry, find out any details, explain where there are discrepancies. I know this property to belong to this person. I need more details so that I can present it before the master for the proper decisions to be made. Should there be any issues, for example, accessing certain information because names are different or anything like that, there are always courts that one can always approach, lay your claim before the High Court, explain why it is important that you need that information, and the courts will generally allow you to, give you the court orders and the power to go and collect the information that you need. Now, on the next slide, I'm just going to cover briefly the distribution of assets. Now, a quick recap. We've just said a person has been appointed. They've identified all the assets the deceased had. They've identified all the liabilities the deceased had, and they've also identified all the heirs that the deceased had. Now, when it comes to distribution, the first thing to do is, after everything has been valued, you have to pay your taxes, and you have to pay your liabilities, or the creditors have to be paid. Whatever is then left, those are what are considered the assets of the deceased. And those assets, because remember, we're saying this is a process of winding this estate legally, that means everything would have to be distributed. A dead person cannot continuously maintain to own property, and therefore there should be a distribution. Now, there are different ways and different factors that are considered when distribution is being done. Was this person married? If they were married, there were considerations on what the marriage was like. Was it a civil marriage? We generally call it a 511, white wedding and all of that. Or was it a traditional one? Because there were slight variances that exist in the law. But suffice it, and you'll see this in the next slide, suffice it to know that generally, because of the marriages that we have in Zimbabwe, what usually happens when people are married and one person dies, let's say it's the husband that's died, other than the marital property, there are certain limits that are set by law, and this change from time to time, so cases really depend. It's usually either the marital home, or sometimes when there's no marital home, it's a set figure that they say in cash, that they say this automatically goes to the spouse. And once that is taken out of the pot, the remainder of it, right? So let's say if it was an estate that involved a number of properties, and we've removed the marital property being the house where the husband lived with his wife and that was treated as the family home, if that is then removed to be passed on for use by the wife, the remainder of it is then distributed to all the children and the wife equally as as the beneficiaries. Now, one starts to see the importance of going through valuations because, for example, where there are two properties and there are, say, in this case, 4 children and a wife, that would mean that those properties either would have to be sold and then distributed, or it could be that one person gets one property, one is sold, and the others get cash or anything like that. But it all depends on the different circumstances, different assets that are there. Suffice it for now to really, underline the point that as an executor, you need to have identified all the assets and having valued them. Now, this extends borders. We're not saying when you do this process, you're only doing it just in Zimbabwe. This has to happen everywhere. So, for example, if someone had lived in the UK and then relocated back to Zimbabwe and they pass on in Zimbabwe, it is important to carry out a search in the UK to find out whether there was any property that was left out, were there any bank accounts that were kept there, were there any companies that were, that were operating or anything like that. All of that are the things that we put in the pot for distribution. Just quickly and finally, the next 2 slides. So the next slide again talks about this distribution that we're speaking about, but in terms of a registered customary marriage, which again is treated in the in the same way as a civil marriage. But there are other instances when we're talking about property. The actual property itself, the building itself, has to be looked into insofar as how it was held, because if you own property as joint tenants, that effectively means that you share all these rights. They're split in a way that if tenant A was to pass on, all those rights automatically go to tenant B. Right? Now, I know this is a bit of an interesting one legally to sort of cover, but we can talk about it in more detail. But for now, the important thing to note is there are 2 different types of tenancies people have to a property. There is the joint tenancy, and there is the tenancy in common. The in common bit effectively means that whilst we are both or all tenants in this particular place, we are quite separate insofar as our rights are concerned. And so you see that if tenant A was to pass on, their rights, because they were separate from the rights of B and C, goes to tenant A's beneficiaries. However, going back a little bit, if they were joint tenants, that means we're saying their tenancy was joint. It was together, and therefore everything goes to the remaining tenant. Okay, so I'll just do a nice little recap before I pass on to Aji, who's going to really then talk to you about the financial aspects of everything that's involved in this and what you have to charge and whatnot. So just as a recap, we're saying, as Josh has said, you've been appointed as an executor. And when someone is an executor, either you have been appointed or anyone else has been appointed, they have certain duties. And those duties are about honesty, diligence, and transparency. People should be open to hold an executor to account and make sure that they're doing all of those things according to those principles. And equally, if one has been appointed as an executor, they too must remember that it's a fiduciary role, and therefore everything must be done honestly, diligently, making sure that no asset is left and no beneficiary is left. With that, Haji, it's over to you.
Thank you, Evan. Thank you, Josh. Now, I think what I'd like to touch upon is all of this process is quite involved, and it takes a lot of effort and energy upon the executor, the families, and the like. And why does it matter to us, especially those in the diaspora, about this process and to understand this process and also to consider what should we do now we have this information. As you can see on this slide, it is quite expensive to pass on, unfortunately. Even in death, you still have costs. And you can see here the process of having an estate administered has quite a substantial cost. The master of the court, who is supporting the administration and administering overall process, they will charge and are entitled to between 4 to 5% of the estate's value. So you can imagine, after doing all the inventory, doing all the effort to ascertain the assets, and then settling with creditors, whatever is available prior to that distribution that Irvin just walked us through, the estate is obliged to then pay the master for their administration fee as part of the distribution process. In that process as well, Zimra has to collect its duty on the estate as well, again, 4 to 5%. The professional executor is also entitled to fees, as Josh had alluded to previously. If a professional executor is to be appointed, they are also entitled to fees based on the value of the estate. And finally, if there is property to be conveyed, in this instance, we mean real property, immovable properties access, that is your homes, properties, commercial or otherwise, there is a conveyance fee as well of 4 to 5% as well, the estate fee. So you can see immediately that the estate is subject to almost 20% in fees as part of the whole distribution process. And it's that important for us to understand and to be prepared that there is going to be a cost associated with, but as well, it raises the question, what should we be thinking about, especially those in the diaspora, and those today, what actions should we be taking considering so? And that is a high burden for this. Now, the diaspora actually, we face a very specific complexity and challenges in this process. Not only is the process itself complicated, but as Josh alluded to earlier, there is a difficulty from even commencing the administration process from abroad. There are additional requirements in order to be an executor who's abroad. There's also the challenge of being able to undertake all the activities of identifying assets, being able to process the things like actually follow up on finding assets, finding beneficiaries, being able to take care for the property, and also being able to avoid those liabilities, as Irvin had highlighted. The process is quite fragmented. You are at the High Court, you are in other private businesses and the like, and it does take quite a bit of it. And it is very possible, and we do find it very often, that executors can tire and then become inactive before an estate is settled. And that presents its own problems for the beneficiaries, for creditors, for others who have an interest under there, and even for the masters themselves. And it's really hard as an executor to understand the processes and the obligations when you're overseas. And finally, one of the key things that is really makes it difficult for administering estates, not only abroad but also domestically, is that really we only think about where we are, and there's actually quite sometimes a lack of consideration about the impact, especially tax consequences, both in Zimbabwe and the country of residency, for having to deal with the aspects of an estate, but primarily the distribution. And that also may include the inability to pay fees. So whether it's the fees to conveyancers or legal fees, if you have a particularly complicated estate, and being able to deal with those matters. And these issues arise for many reasons. Like we said, physical presence, the systems themselves are outdated, the transparency around assets, and the understanding of the law itself. And that really presents a lot of challenges. And also just primarily the lack of estate planning. The lack of that also potentially leads us to this. And part of that process of estate planning can really alleviate some of these issues, whether it's preempting some issues or even just having information organized for someone who will be your executor in the future. But of particular concern, especially those in North America, one thing we wanted to really highlight and bring to your attention and to consider regarding deceased estate is the fact and is the priority that taxation is actually a key issue. And we're talking here really taxation as it regards to those who are primarily inheriting, and for those who would be, to be deceased and to no longer with us, it's actually being able to realize the intent of that you would have wanted for your assets or for those who you leave behind. And specifically what we can point to is the IRS generally requires that all U.S. citizens and resident aliens, essentially all those who are subject to taxation and to the laws of the United States, have to account for their worldwide income. And that doesn't matter what kind of income it is, whether it's rental, business income, and the like. And it includes any gains or extension to wealth via inheritance, and any asset sales and the like. It has to be accounted for and is subject to the taxation rules. And specifically, one of the issues to consider here is even trusts, especially foreign trusts, present very key difficulties for those in the diaspora, especially in the United States. The U.S. has a very punitive tax regime related to foreign trusts. So a trust in Zimbabwe that might have been established by a deceased is subject to punitive taxation if for beneficiaries to that. So again, it presents a consideration that an executive, a would-be donee must consider in that. And essentially, to navigate this topic of taxation, it's important to understand what the current tax position would be for a beneficiary and for those administering the estate, and is all that income being reported correctly? Questions like, how are the assets actually held? Are they held personally? Are they held in the name of the deceased, and would they be held in the name of the beneficiaries, or are they through a company? And so it becomes very difficult and challenging and a very complex undertaking for not only the executor, but also potential beneficiaries. What will happen to them as a result of having gone through this process? And so it's very important, and I think it raises a key issue that we have to undertake that planning and to consider and be prepared for that outcome, especially from the diaspora, let alone considering the issues of administering a state in Zimbabwe. What are the implications when in the other countries that are living or resident in? Now, finally, to consider this, time is not a cure for issues, especially with taxation. The IRS does have the power to go as far back as they need to regarding issues of not failing to file, and as well for beneficiaries who inherit assets and have taxes owed to the IRS. And what we have known, and I think what continues to be a consideration, is sometimes the amounts involved with assets or income out of Zimbabwe is that they're considered to be nominal or de minimis to most people, small amounts that no one should care about or would not care about or be aware of. But we do know that, and we do point out that the common reporting standard regime that's being adopted by many countries around the world has been fostering and encouraging many countries to engage in information sharing about other tax citizens or other taxable individuals from other countries in an interest of being able to identify and be able to levy taxes on income for all their citizens, no matter where they might reside. And I think we can understand, as we see Zimbabwe seeking more ways to collect more taxes and income, that it would not be too much of a stretch to consider that at some point Zimbabwe may decide to participate in the Common Reporting Standard, which means two things. They can understand and identify and give access to information about citizens and their income and assets in other countries. But just as much, other countries might know about the income and assets you're entitled to while residing in other countries. So it's, again, one of those things where being prepared and planning ahead and being compliant in advance would be of interest to someone rather than waiting until the day it does happen and the like. It is something to consider not only for those currently administering estates, but for the future of its states. And really the takeaway we would like to leave you with today is really, what should you be doing to be prepared? We look at it that those in the diaspora, whether it's for themselves or for family members where they may potentially become an executor, is undertake some estate planning. Ask the questions, reach out, speak to people, and really look to say, how can I have my affairs in order so that you do not have these challenges do not get passed on and my wishes are actually attained. Look to create a will so that, again, if you have a will, some of these issues are already addressed in advance and some of this process can occur. Look to establish a trust. I know I mentioned that trusts have their own challenges, but there are ways to plan and structure around it. But look to do a trust, because a trust actually means whatever assets are subject to a trust are outside the process of estate administration. Make sure for businesses that you have operating and the like, you have a business continuity plan. As they say, as a person is no longer with us in the flesh, the business must continue if you do not want to lose that work. And also consider being who you appoint as an executor, or also for some people, maybe it's ensuring where you may be considered an executor. Maybe it's informing someone, maybe you do not have interest to be an executor, so that they choose somebody who is able and capable of being an executor. And finally, as well, going along with that is considering your tax consequences and the like, and engaging in tax structuring. Of course, we're here as well to be able to support. We can support those of you who have any questions on matters of estate planning. We can also assist you, again, those who are navigating currently or in the future are navigating the estate administration process. We can support you there and be able to advise you and be able to guide you in terms of identifying those where you can get assistance, or really to be able to execute some of the issues or think about strategies of how to actually fulfill your duties. That might include investigating assets, considering how to manage businesses or legal organizations, and as well as looking into matters of tax structuring, especially on the cross-border side. Our ability to be able to work and collaborate in specific jurisdictions and across jurisdictions is something you should look to. And we encourage you to actually take this opportunity to have a conversation with us. Reach out to us. Let us understand how we may be of assistance, or whether what your challenges are, and maybe we can be able to point you into the right direction. And I think with that, we thank you for having attended and having listened through the presentation. And we will now open up the floor to look at any questions that people have. Please add them into the Q&A, and we'll go through those and try to address them. And if there are no questions, we will address some of the matters that maybe come to mind that we didn't touch upon. But we'll spend a bit of time here to hear your questions and the like. If you don't feel comfortable or otherwise to put any questions in the Q&A section, please do use the link that we've placed there to book a consultation and reach out. And we'll be happy to have a discussion with you and be able to find if there's a way we can help you out. Thank you, and we'll look to the questions. If anyone has a question, please let's have it.
Yes, thanks very much, Haji. There actually is a question. Ian has sent a question in the chat where he asks this: what do you do if a will has been declined by the master on the basis of, for example, a thumbprint, but the whole family has resolved to respect the wishes of the testator incorporated in the invalid will? That is, in short, how do I bring back an invalid will to life? Now, that's a very good question there. And there are a number of things that are involved in it. So, like, for example, the first thing, once the master may well have determined that, there is a question of looking at that from a legal point of view, and whether or not the master's decision ought to be appealed to the High Court to actually determine whether indeed the will is invalid in the first place or not. If, for example, it has been determined that, yes, the will is invalid and you can't proceed with it, now you can't really rely on it, because once it's been called invalid, that means you can't apply it. However, the person who's then appointed as an executor still has those duties, to fulfill, identifying. So the will be a very good starting point. Make sure that As we were saying, they've gathered all the assets, they've gathered all the beneficiaries and whatnot. And then prepare everything according to what we were discussing, ready for distribution. It is then dependent on each individual beneficiary who is entitled at law to give up whatever right they would have had and say, well, look, actually, I know, based on that will, even if it's invalid, that the deceased intended to give it to X, and therefore I want to give up my share to make sure that it goes to X, and I fulfill the play a part in fulfilling the deceased person's wishes. So that becomes important to actually follow that process, doing it transparently, honestly, diligently, as we're discussing, because you never quite know with these things. If, for example, the number of people that are involved in that meeting say, well, look, this is what we want to do because this is what the deceased wanted. If it then turns out that there was a creditor who was never actually consulted, who was actually never paid out of that, then the executor now attracts those personal liabilities because they still had a duty to make sure that all of those things had been done. Now, whilst we're on there, I'll just quickly touch on this. Many people don't realize this, that these obligations that we're speaking about, again, just as we was talking, in relation to the IRS and digging into old affairs, so can deceased estates. It's not that because it's been closed and wound up that it becomes the end of it. People can still reopen these, and challenges can still be placed, and indeed not only for the estate to be redistributed, but also even personally to the executor for not having done things properly. Now, the executor is a very difficult job, and this is the final point I'm making before others jump in on this. But there are questions of making sure that whatever is in the will is exactly as recorded in the deeds, being diligent enough, because imagine if the deceased person had made a mistake and put the wrong address, or maybe there were issues where people, actually don't have the right birth certificate, right title deed, it's not clear, there are mistakes that have been made. All of those things are challenges that the executor has to deal with, attending at the offices, going to court if it's necessary to make sure that those are rectified. The short of it is the executor must really be diligent enough to identify every single asset and every single liability that belong to the deceased person. Aji, Josh, is there anyone else? Anything else to add?
I just wanted you to touch on reopening estates, because I think you're sort of alluding to that as well. And that's one of the common questions, right? How do you look back and revisit certain things if they are done incorrectly or they weren't followed?
Yeah. So well, number one, when an estate has been closed, you would want to open it, and so there is a process that you have to follow, right? Because when an estate has been closed, that means the executor no longer has any other duties. So you go back to the master in the first instance, and you tell the master that, look, I have these challenges, and this is what I need to do. You effectively put in the master on notice that you want to have the estate reopened. Now, technically speaking, once it's been closed, it means the master can't on his own reopen that estate. And therefore, you have to make an application to the High Court and, explaining the reasons why you want that estate reopened. Now, there are a number of things that come to mind. Number one, if, for example, you are a beneficiary and there is every single evidence, to prove that you are a beneficiary, but by whatever reason you were missed out in the distribution, that could be a ground for you to lay claim. If you discover assets that were missed out, and this is often the case, right? I know a number of places in Zimbabwe where it started being grandmother and grandfather lived there, family, mom and dad lived there, passed on to grandchildren, and it continues. And people just generally say, well, it's in the family. Some of these properties, for whatever reason, are left out of distribution, and people just say, well, it's in the family. All of that is property. They're all assets that must be accounted for, distributed properly and according to, to the laws. So you make an application to the High Court, and then, give them the information and the evidence that you're relying on why the case has to be opened. Now, there is a small little point to make there, though, that window of claim is not open in perpetuity, right? It starts running from the time you know of the thing you want to complain about for a period of about 3 years. Now, this period can change. It depends with the law, but presently it's 3 years. So an example is, if I identify in a newspaper today that property belonging to X is being sold and I'm entitled to it, and I know I need to act on it, I now have, as of today that I've read that article, 3 years to go and ask for that estate to be reopened so that property be distributed properly.
Yeah, and I think, Evan, your answer really, again, I think really emphasizes one of the key things is that it's not a simple process. And one of the ways an executor can protect themselves personally, as well as ensuring fairness occurs, is having, where need be, to engage advisors to help them navigate the process. Because again, when you think about it, one of the issues that would come up is, work that is not done diligently or correctly does raise the specter of challenge and a potentially successful challenge. So I think if you find yourself as an executor, being able to dispense with those duties, or at least informing yourself, is a very valuable thing to pursue. We have a question here as well. It comes as asked us, what are the two types of joint ownership, which type allows each owner beneficiaries to inherit their share? And so I believe this is what Evan had talked about, the difference between joint tenancy with survivorship rights versus a tenancy in common, which means that each tenant or owner's beneficiaries will inherit the interest in that. So it does not have survivorship rights. So I think the question was trying to see which type of ownership is important to ensure that the owner's beneficiaries who will inherit it, not the other tenants. And that's a tenancy in common. And again, this is something that, again, we encourage you to, if you find yourself having assets or otherwise that are owned by other co-owners with whom you have joint tenancy and don't have otherwise, is to have that reviewed by a legal advisor to be able to help you understand your ownership rights, and if changes need to be made, how those changes can be made to ensure your intentions will be realized. And I think that the next question, maybe for Josh, is there a way of retrieving estate documentation which one may have lost or misplaced from the court offices in that? And is FLP able to assist with something like that? Josh,
you're on mute, Josh.
Yeah.
Okay, thank you. But generally, I was saying generally, when you file documents at the master's office, at the master of the High Court's office, those documents are public documents, which means that you can walk you can walk there, get documents, and get out. But of late, there's been a lot of corruption cases that have been going on at the master's office. So generally, what they require now is at least a person with a power of attorney to access those documents, or experts or professionals that have been appointed by the master or that are recognized to do that, which we have the capacity to go there and retrieve those documents for you and do that. So in a nutshell, what I'm saying is, yes, it's possible to get those documents as long as they've been filed with the master of the High Court. but I would assume that maybe the executor may have had some of the documents in his possession that were not necessarily filed. So it could be something that we can have a conversation with you separately from this to sort of understand what your specific needs are and what exactly is it that the sort of documents that you'd want. So I would advise that you make use of the consultation that we spoke of earlier, the 15-minute consultation, then we can take it from there.
And following on to that, Josh. Oh, sorry. Yeah, go ahead, Evan.
Okay, yeah, I was just going to follow up on that and say thanks, Josh. Now, you see, Tawanda, our experience is not just limited to the Master of the High Court when it comes to these documents, because like Josh says, yes, we are able to help you retrieve those lost or misplaced documents, but for any department, because for example, if you have if you've lost a title deed and you want to retrieve it, all of that becomes part of the process of making sure that all the assets have been identified. So it's not just limited to whatever has been presented at the Master of the High Court. It extends to all the departments, even if it's councils, registrar of deeds, companies, even the surveyors general. There could be all sorts of departments. Now, this is not just about lost or misplaced documents. It's also about documents that have wrong names, wrong addresses, and therefore you having to prove that indeed this is what I'm referring to is proving difficult. That's something that in our experience we've had to deal with a number of times. And I know it can be quite frustrating if you know something as a matter of fact, but you're holding a document that is a different name and the relevant offices are not listening to you. So all of that and many other such issues are things that we can help with.
Thank you both. I've got another question here, and then we'll see if there's more. But there was a question regarding who is required to be present in the meeting of the Master of the High Court where there's no will. And also, if beneficiaries do not intend to sell property, does a valuation of the property really matter?
Yeah.
Josh, yeah, maybe, yeah. Evan or Josh, I think if you want to take one of those.
Okay, let me take a first stab at it. Now, you know, what Josh was explaining earlier, and he can expand on this, I think, on the number of people, the type of people, number of people that need to be there at that EDIC meeting. But I'll start by focusing on the whether or not it matters to value property if you don't intend to sell it. Now, given that this is a process that really has to be transparent, done, you know, diligently and whatnot, our suggestion is all those steps are necessary to make sure that all the information is presented before the Master of the High Court. Now, there is an expense that's involved in that, and so one may think, well, what's the point of having to pay these experts to value this property, expend a bit of money, when in fact we don't want to sell all of that. Now, the transparency of this process is that it's supervised and managed by the master. Whoever is appointed as the executor you know, must follow through with the process of making sure that all the liabilities are identified, all the creditors have been told, and that all the beneficiaries have been identified. And with all of that, if all of that has been done and presented before the master, it might then be that a question is put to the master of whether or not, you know, if it's okay to distribute that property in by way of, let's say, if it's a sizable estate where there are 4 beneficiaries and there are 4 properties, it might be that the suggestion is, well, can we just give 1 property each as opposed to valuing it, selling it, and dividing the money? All of those are things that are acceptable before the master. The point, however, is that the master will be guided by the law, and the law would be saying, unless the particular beneficiary has said, I am happy to forgo whatever I'm entitled to, the master will be looking to ensure that the distribution is being done equally. So the valuation really then is something that not only plays a part in so far as selling it, but it becomes a way for the master to determine whether the distribution is to be done fairly and equally. Now, over to you, Josh, to just talk about the number of people that will be at the EDIC meeting.
Okay. As a general rule, right, when that meeting is called, it's meant to pick, the purpose of that meeting is meant to pick an executor. But there are a lot of people that are involved. Sometimes it's a situation where there are children out of wedlock, in wedlock, and there are many other siblings from different, parents and stuff like that. So what the master seeks to do is to make sure that things are done fairly and the estate is administered in a way that is lawful and no one is going to take advantage of the position of an executor. So the people that must be there will include the creditors, the people that are owed by the estate. Those are very important to be there. But the family, other than those people who are external in this case, they would require that the beneficiaries be there. The people that would be beneficiaries are attending, which would include the children, the spouses, and sometimes what the law would require is, particularly if we're speaking to the diaspora market, the people in the diaspora, is that they may not be able to be physically there. They can appoint someone using a power of attorney to attend on their behalf, or they can appoint an expert to just be there on their behalf and just listen in and take instructions on what executor is going to be picked in that. So it's family members, the children of the deceased, and sometimes the siblings of the deceased or the parents of the deceased are allowed to be in that meeting. So again, it's important to point out that this EDIC meeting is generally advertised in the newspapers. So once that EDIC meeting has been advertised, everyone who has an interest in that estate can attend that meeting and be present. Yeah. So I think in a nutshell, I hope that answers you.
Thank you, Josh. Seeing as though we are past our time and we've had people well engaged throughout, we're very
Sorry to interrupt. There's a question it's a common issue surrounding names, name errors for amongst relatives, and the evidentiary burden there when you're showing up for picking up death certificates or going through the process. I think sort of clarifying that for people would be good as well, since it's a reoccurring issue that we've seen coming from Zim.
Okay. This is something that I sort of touched upon a bit earlier, but just to expand on it, what I was saying there is that the winding up of a deceased estate is something that is done by the master of the High Court. At law, it is the master who has the responsibility to ensure that that process is done properly and is brought to an end. Right, so that's a very good starting point. So if within the family there are discrepancies, say in the names, and you turn up, at either to get a death certificate or you want to get a title deed or anything, and you're facing challenges that you don't have the same name. Usually, in many government offices in Zimbabwe, they would say, they want an ID with the same surname and stuff like that. And often they may refuse to help you if there is a difference. The first port of call really is to go to the master and having a conversation with the master. And if the master understands what it is that you want to collect, why you want to collect that, the master will issue out those letters that Josh was referring to. And those letters will, in fact, empower you to be able to appear before any office and get whatever it is that you need to get. If for whatever reason there is resistance or there are delays at the masters, then the thing to do is to go to is to go to the court. You can apply at the High Court, lay your case, explain to them why you want that information, and they'll be able to give you the court order for you to get the information you need.
Excellent. I think, I think we can bring proceedings to a conclusion here. We thank you all for having attended and spent time with us. We hope that this has been helpful and insightful and at least gives you a better understanding than you had beginning today. And we encourage you to please reach out if there's anything we can help you with, be able to navigate this process, or even just provide additional insight. Do come and follow us, and you can find us on LinkedIn, or you can come to our website, www.flp.legal. And you have our emails on there on the screen if you need to reach out. We do encourage you to make use of the technology and the reach out, and keep an eye out. We will be continuing additional webinars in the future on different topics, including estate planning in the second quarter of this year. We will dive deeper into the idea of estate planning and how you can potentially approach it and strategies related to that. Thank you, and have a good afternoon.
Bye.